Hello, dear learners. Welcome in the class of Industrial Law. In this lecture, we are going to learn the law related to social securities in the industries. In this, we will learn three laws which are the Workman Compensation Act of 1923, the Employees Provident Fund Act of 1952, and the Payment of Gratuity Act 1972. These are the laws related to the social securities of a workman or the employee. First is the Workman Compensation Act of the 1923. This act ensures that workers or their dependents receive financial support in case of a work-related accidents or a disease. This is a social security law. This law is designed to offer protection to the workers and to their family members in the labor-intensive sectors. Objectives of the Act are to compensate the worker for the injury, disease, or the death caused during the work, or to establish the liability of an employer to compensate the worker. It is an act to protect the worker from the financial hardship arised because of the law related work related accidents. So this is a act to social securitize the workman. It has a broad application in the industries and factories because industries and factories can cause such accident or the harms which the workman or their family has to tackle. The scope of this application: this act applies to the workers in the factories, mines, construction sites, and all other hazardous occupations. But this act does not apply to the employees in the managerial sectors, administrative, or the clerical roles, which are not that hazardous in the nature. The types of compensation which are provided in the Workman Compensation Act of 1923 are of three types. One is the death. When the workman dies in the work related accident, then the compensation to the legal heirs. In the case of temporary disablement, the compensation uh, to the workman because of the injury or the accident caused during the work. The compensation related to permanent disablement, the workers are uh, eligible to get compensated for the injuries who has been suffered during the work period. They are eligible for the compensation for the permanent disablement, or the workmen are also entitled for the medical treatment because of the work related ailments. So this act applies to all factories, mines, plantations, railways, construction, uh, but it does not apply to non-hazardous work environments such as the government departments whose works are managerial, clerical. The definition of the workman has been defined in the Workman Compensation Act of 1923. It means a worker who is working under a contract in the industry. Nature of injury, it means the type of injury caused which has been caused during the working hours of the worker. The time limit to claim compensation has been defined in the Workman Compensation Act, and the limitation to file for the compensation is 2 years from the date of the accident. The Workman Compensation Act has excluded some injuries which are self-inflicted harm such as suicide attempts. It also has excluded the accidents which has occurred due to the influence of alcohol or drugs. The act also exclude the injuries arised outside the scope of employment, that is the personal activities. The contract workers or workers in informal sectors are unless specifically are excluded. Liabilities of the employer. It is a liability of an employer to compensate the injured or the death worker. As we discussed, there are types of compensation for the temporary disability, for permanent disability, for death, and for occupational diseases. Occupational diseases can be caused because of the nature of work in the sites. There is a specified compensation formula prescribed in the Workman Compensation Act of 1923. In the case of death, the percentage of the employee's wages should be paid to the dependents, that is, the spouse of the dead worker, or the children of the dead employee, or the parents of the dead employee. In case of a temporary or a permanent disability, the compensation is based on the degree of the disability of the worker. Permanent disability is rated according to the schedule provided in the Workman Compensation Act. It is depend on the severity of the injury. The death disability due to the occupational diseases such as silicosis. These are types of severity which are caused because of the nature of work in the industry or the factory. Then the question arises, what should be the amount of the compensation? Amount should be fair and reasonable. The compensation amount should be fair and reasonable, and it depends on the severity of the injury or the death workman. In the case of temporary disability, 50% of monthly wages are to be paid for the worker uh, for the temporary disability period. In the case of permanent disability, the worker will not be able to work anymore. In such type of disabilities, the amount calculated is a percentage of a worker's monthly wages multiplied by a factor based on the degree of disability. This is a question which should be decided especially by the authorities. In case of death, the dependent family members of the deceased worker are entitled to fixed sum as compensation. In the occupational diseases, fixed compensation amounts are provided depending on the nature of the disease. So the Workman Compensation Act is a social security to the workman who is injured in the working hours. Then the procedure, how to claim the compensation. The procedure to claim compensation under the Workman Compensation Act is to issue a legal notice of injury. Workman has to notify about the nature of the injury to the employer. Then he should file a claim of a compensation to the respective relevant authorities, which is a commissioner of a workman compensation appointed by the government. The claim should include the medical reports and other evidence of the injury or the death. In the case of the dispute, the resolution must be achieved by the commissioner of the workmen's compensation. Sorry. Sorry. Then the process for claiming of compensation, as we discussed, it is a notification of injury, then the medical examination, filing of a claim case, then the dispute will be resoluted. Now the Workman Compensation Act is the act uh, uh, passed in the 1923. The Workman Compensation Act has been amended several times and it reflects the changes in the wages scope of the workers covered and the compensation amount. Some of the notable amendments is of the 1929 amendment 2000 and the 2009 amendment act, which raised the compensation amount and expanded the scope to include a larger number of workers and industries. Advantages of the act, as we understood, the advantages of the act are visible, which are the protection for workers, and it also makes employer accountable for the safety and health of the worker in the hazardous jobs. It is This act also provides for the security for the family members of the worker who are dependent and ensuring them the economic stability. With time, there are challenges to implement the law, and such challenges are the limited coverage. The such challenges are the complexity in the claims. It is a inadequate compensation. The employer always tries to uh, compensate inadequately to the worker, and one of the main challenges is the delayed disbursement. Justice delayed is justice denied, as it is said. Delayed disbursements causes the dependence of our workers to the financial trouble. Since the Workmen Compensation Act is a law related to the social security, it is a critical piece of legislation which ensures the workers receive compensation, proper compensation. So here we are done with the Workmen's Compensation Act 1923. Now the law related to social securities in our syllabus of Unit 3. The second part is the Employees Provident Fund Act 1952. Employees Provident Fund, which is generally termed as EPF, it was introduced to provide a social security scheme for employees, workmen in India. It is a retirement savings fund designed to secure the retirement after retirement life of a employee. This act is applicable to establishments which has 20 or more than 20 number of employees. It offers retirement benefits in the form of provident fund, pension scheme and insurance. So the type of benefits in the employees provident fund are retirement savings, tax benefits, interest on contributions, financial security in case of death or disability. So it is a broad saving scheme in terms of the employees. Objective of the act are to ensure financial security, to provide a compulsory saving scheme for the employees during their employment, to provide benefit in case of disability, death or resignation to the employee, and to ensure social welfare through pension, provident fund and insurance. Key provisions of this act are the Provident Fund. The Provident Fund is a mandatory saving scheme where both employees and employers contribute a specified percentage of employees' wages. Then pension scheme, which means a monthly pension to employee after retirement, or a monthly pension to the relative or a family of member of an employee in case of a death during service of the employee. There is an employees deposit linked insurance. It is a type of insurance in case of a death and a nominee of a deceased employee is entitled to lump sum amount. Provident Fund, Pension Scheme, Employees Deposit Linked Insurance are the key provisions of the Employees Provident Fund Act 1952. Contribution to the Provident Fund. How contribution will be made in the Provident Fund scheme? Employees will contribute 12% of the basic wages or the dearness allowance and the retaining allowance in the Provident Fund scheme. Employer will contribute 12% of the basic wages, dearness allowance and retaining allowance. That is 50% of employer's contribution goes to the employees pension scheme and remaining to the provident fund. So employers contribution will be divided in two types, which is the employees pension scheme and employees provident fund. Exemption for a small establishment. The establishment which has fewer than 20 employees are not mandatory to be covered under the EPF scheme. So, what is the procedure for enrollment? How can employee enroll himself for the benefit under the Employees Provident Fund Act? The employee can enroll himself automatically if the scheme is applied and eligible in the establishment. Employer must register their establishment with the Employees Provident Fund organization and obtain a universal account number to the each employee. It is the duty of a employer. Provident Fund account. There should be a separate PF account which should be opened for each employee with the EPF. Withdrawal of Provident Fund. Employee can withdraw their savings, that is the Provident Fund balance, when they resign from their job, when they retire from the service after the attaining the age of 58, or when they are employed for more than 2 months. In the case of death, their nominee can withdraw the balance. New concept of transfer of provident fund. Employees can transfer their provident fund balance when they change jobs. This is a new concept. It has been amended in the year 2017 using the universal account number. What are the penalties for non-compliance of the provisions in the Employees Provident Fund Act? The penalties for non-compliance are late payment. When the employer fails to deposit his contribution, then he has to face a punishment in the charges of fine and the interest. In the case of non-compliance, when employer fails to comply the provisions of this act, then he may face the legal action and the fines. EPFO has authority to conduct inspection and audits of establishments to check the uh, compliance of the Employees Provident Fund Act. EPF Act is the act of 1952 at the time of the independence. After that, this act has been amended sometimes. That is in the 1988, which introduced the Employees Pension Scheme. In the year 2016, Universal Account Number and the ease of access, increased transparency has been amended in the year 2016 by Government of India. In this, under the EPFO portal and the mobile app, the employee can manage and access his provident fund scheme. So this act, Employees Provident Fund Scheme, is uh, applied in the whole of India, and it benefits the employee for after the retirement for the pension scheme and after the retirement for the lump sum amount of money. So the benefits This is definitely benefited to the employee in the form of financial security post retirement in cases of death or disability. It also offers a tax saving benefits through contributions in the EPF account. It is a reliable source of income during the retirement years, and it also benefits to the employers. It impacts positively on the employee retention and the satisfaction, and uh, it should be avoided, and the non-compliance of the act should be avoided by the employer to avoid the penalty. So the universal account number, retirement pension system, these are the some changes which has been came aftermath of the act, but the overall employees provident fund act of 1938 is ensuring employees save for the retirement and protect in case of unforeseen circumstances such as death or disability. This how in the industrial law, the Workman Compensation Act and the Employees Provident Fund Act of 1942 52 is changing the lives of the employee. The another act which is responsible to the law related to the social securities is the Payment of the Gratuity Act 1972. Payment of the Gratuity Act is a legislation that mandates employer to provide a gratuity payment to employees who have rendered continuous service to the establishment or the industry or the factory. It is a statutory benefit. Gratuity is a statutory benefit paid to the employee as a reward. It is a reward for their long term service in the organization. This act is applicable to the employees in the establishment in where 10 or more than 10 number of employees are working together, and it is enforced by the Ministry of Labor and Employment under the Government of India. This act ensures employees receive gratuity payment for the service they have rendered to the organization or when they have to leave the organization due to retirement or illness or death. This is a social welfare scheme which benefits employees upon their exit from the employment. The definition of employee is different in all the schemes. In the Payment of Gratuity Act, the definition of the employee is the employee who has worked in the establishment or factory for uh, 5 years or more than 5 years of continuous service. The workman who has worked for the continuous period of 5 years is an employee in the meaning of the Payment of Gratuity Act. Gratuity means a lump sum payment amount made by the employer to the employee in recognition as a reward to the long term continuous service. And employer is a person who hires or who pays the employer, who is responsible for the working of the employee. So it is uh, a social security act provided to the employees who have worked for 5 or more years as a continuous service. There is a calculation formula how the gratuity will be calculated. It has a specific formula which says the last drawn salary into 15 into number of years of service divided by 26. Maximum gratuity. This is an amendment in the Act which prescribes that the maximum gratuity payable to the employee is rupees 20 lakh. 20 lakh is the maximum gratuity which is payable to the employee under the Payment of Gratuity Act. So, uh, how do you claim the gratuity amount under the Payment of Gratuity Act. For this, you have to give a notice of the intention to leave the job, that is the notice period of 30 days before leaving, to the employer. It is also a employer's responsibility to pay the employee after the 30 days when the employee will leave the organization. In the claim application, it is a formal application submitted to the controlling authority. And the dispute resolution, if through the claim application and the employer does not uh, banks upon the gratuity payment, then there is a controlling authority of the labor commissioner uh, who has the authority to resolve the dispute arised under the Payment of Gratuity Act. Then there are exemptions, which means the non-eligibility, who are non-eligible to get the gratuity. And that is, first, obviously, the basic requirement, that is, when the worker has not worked for the continuously 5 years, then he is not eligible. The exempted employer, the establishment where less than 10 people works, are the establishment which had been exempted under this act. Dismissal or misconduct, in the case the employee has been dismissed for the misconduct, then they are not eligible for the gratuity. What are the benefits of the gratuity which the employee feels of? The one of the best benefits which employees is benefited from the Payment of Gratuity Act are the financial security for employees. And when after the 5 years of the continuous service, a employee leaves or resigns, then he will be paid a lump sum amount which will secure his financial asset as an employee. Gratuity acts as a reward to the employee's motivation and retention to the organization for a longer period. The another benefit of a payment of a gratuity is the legal obligation for employer. It is a duty of a state, that is the government, to work for the welfare of the employees. So it has been made legal obligation for the employer to reward their employees for their long service in the form of gratuity. So these are the three laws, that is the Workman Compensation Act 1923 in the case of accidents, the Employees Provident Fund Act 1952 for the savings and the pension scheme, and the last, the Payment of Gratuity Act 1972 to get reward in the form of lump sum for the continuous service to the organization. There are definitely some challenges, such as the lack of awareness. There is a lack of awareness of their rights in the establishments. There is a complexity in the calculations. There is a delay in the payment from the side of the employer. There is a limitation on the small establishments. So overall, the Payment of Gratuity Act, the Employees Provident Fund Act, the Workman Compensation Act are the act which provides the law related to the social security of the worker or the employee in the industrial sector. So these are the laws related to the social security of the worker in the industrial sector. This was the unit 3 of the industrial law. Thank you for learning.